We are going to critically discuss legal subjectivity with reference to the vulnerability theory and in the context of supported decision-making. Legal subjectivity can be defined as the liberal legal subject. A. Greer defines the legal subject as a socially decontextualized, hyper-rational, willful individual, systematically stripped of embodied particularities in order to appear neutral and theoretically genderless, suggesting that the legal subject is a neutral person, lacking context, thus demonstrating a paradox to the reality of humans. Martha Feynman enhances this notion through her vulnerability theory, demonstrating how arguably the liberal legal subject is unrealistic and perhaps non-existent in society. In this presentation, we will analyse the idea of the liberal legal subject against Feynman's theory in relation to supported decision-making, using the legislation of the Mental Capacity Act and in reference to the United Nations Convention on the Rights of Persons with Disabilities, in order to convey how the concept of supported decision-making in law perhaps doesn't fit with the legal subject.
The traditional idea of the liberal legal subject is an autonomous, rational, and self-sufficient man. This concept of the liberal legal subject implies that the individual acts alone, without any support from others. This individualistic approach taken by liberal legalism is prevalent in Western legal traditions, as stated by Cook. Such an atomistic approach omits any sense of realness. In the context of supported decision-making, liberal legal ideas take form in acts such as the Mental Capacity Act 2005. The MCA places limitations on an individual's right to exercise their decisions if they fail to satisfy the test set out in Section 2 of the Act. An allegedly flawed decision on the part of the individual with a mental impairment means that an agent is required to substitute their decision for the beneficial interest of that individual. Case law suggests that wishes and feelings to be the starting point, but this may be overridden on grounds of a public interest or the individual's interest.
In analysing this test set out within Section 2 of the MCA, a reliance upon liberal legal views in setting a standard of such individualism is arguably too far socially decontextualised and unrealistic in practice. The threshold that the MCA inadvertently sets lacks an appropriate acknowledgement of reliance and social dependency on others. This is because no one makes decisions entirely on their own, and we're all somewhat reliant on others where wider contextual factors play a part. This is expanded on by Hunter, who states that liberal legal subject does not take into account the inherently social nature of human beings. Social relations with others are constitutive of the human, not an optional add-on. Therefore, it can be argued that the Mental Capacity Act 2005 offers a flawed construction of the legal subject in the context of supported decision-making, but arguably robbing individuals of their autonomy, using instead substituted decision-making.
In continued support for the notion that Feynman's vulnerability theory offers a more appropriate analysis of the legal subject in the context of supported decision-making, it must be noted that the MCA inadvertently sets an unfair and perhaps even discriminatory standard for those with mental impairments. By virtue of an individual's impairment, they are subject to a higher level of scrutiny than that of someone without a mental impairment. For example, Minkovich and Danda state, a person's decisions would generally not be subject to such scrutiny but for his or her diagnosis. It is this direct reference to mental impairments that is problematic and where the jurisprudential flaw lies. Beverly Clough also highlights this problem, stating, by focusing on the internal decision-making abilities of individuals, it is seen to marginalise the multivariate and multidimensional factors which impact on meaningful decision-making for all individuals, regardless of impairment.
Supported decision-making is essentially something all humans do daily, and the standard set by legal liberalism fails to take that into consideration. So why is such a high standard placed on those with mental impairments, and why are they alienated in such a way? Therefore, we argue that the paradigm shift, as seen in Article 12 of the UN CRPD, offers a more feasible approach to legal subjectivity in the context of supported decision-making. Article 12 considers all people to be deserving of legal capacity by considering it a universal right, something that cannot be denied on the basis of mental impairment. In this, it offers a new cosmopolitan approach to legal capacity based on ideas of shared personhood and acknowledgement of universal reliance on myriad supports, unlike the MCA. This, we contend, ought to be the new status quo.
A problem with the UNCRPD is that it may be argued to be vague and expose individuals to potential exploitation by going perhaps too far with permitting autonomy on such a universal scale. The subject may be seen to understand all the information, but someone else is behind the scenes pushing them. However, this is only limited to exceptional circumstances and therefore should not be a sole factor in advocating against the UNCRPD.
Regardless of these minor potential consequences, it is important to note that Article 12, subsection 3 of the UNCRPD is more accommodating of our inherent dependency to the creation of positive obligations placed on the state. For example, Martha Fineman states, "We have become so fixated on the myth that citizens should be autonomous that we fail to recognise the inevitability and normality of dependency." Ultimately, the pros of the Convention outweigh the negatives significantly, especially in light of the vulnerability theory, since supported decision-making is favoured, which we argue to be non-discriminatory, particularly compared to the MCA.
Martha Fineman advocates for the responsive state. This is where the state helps the individuals by increasing our resilience. An example of this is where the state has provided state support in the UK for their citizens through institutions such as the NHS, which has increased our resilience. Although there are still problems that occur due to strict adherence to a liberal view of legal subjectivity, and this can be seen through the impacts of COVID-19.
In the Mental Capacity Act 2005 and Deprivation of Liberty Safeguards during the COVID-19 pandemic government paper, it states that it may be necessary for a number of reasons to change the usual care and treatment arrangements of somebody who lacks the relevant mental capacity to consent to such changes.
Applying COVID-19 to Feynman's argument, it's evident that we are all born within a state of vulnerability, and as Feynman states, it should be understood as a universal and constant inherent in the human condition. Not only do problems arise with reference to a liberal view of the legal subject in reference to supported decision-making, but these problems are worsening due to recent world impacts.
In conclusion, Feynman's vulnerability approach challenges the traditional liberal legal approach to legal subjectivity by illustrating how it fails to consider the reality of day-to-day decision-making. It can be argued that the liberal approach to decision-making, as set out in the MCA, sets an unrealistic standard that few non-disabled people are ever able to reach, thus omitting any sense of realness. Consequently, Feynman's vulnerability theory offers a more realistic and accommodating approach. Therefore, there are numerous complications when using a liberal approach on grounds for supporting decision-making when referencing this to the vulnerability theory. Thank you for listening to our presentation.